Tēnā koutou. My name is Dr. Caroline Keane. I'm a sociologist and founder of Socio-Digital Research. I'm really pleased to open this session on safeguarding children's data privacy today, because it's a subject that's not often addressed in New Zealand, as there are so many other concerns about children's use of the internet, and these often appear to be more urgent and take centre stage. So this panel is an important milestone, as I feel children's personal data privacy is an important conversation that is yet to begin in New Zealand. And so I'm hoping that this kickstarts awareness of some of the issues and challenges in the road ahead. So while there's been some work that has been developed within government, which impacts our government's handling of our personal data, there appears to be a lack of mahi around the protection of children's privacy in relation to commercial and institutional actors, particularly within education in New Zealand. So today, I've asked representatives from 3 government departments and the Office of the Privacy Commissioner and the New Zealand School Trustees Association to discuss how their work intersects with the issue of children's data privacy, and particularly in relation to institutional and commercial data collection and use. So I'd like to welcome Mickey Searfoot, Selena Smeaton, Debbie Burch, Sed Simpson, and Kate Rickaby, and thank them for taking part. And a big thank you for Debbie Burch, who it's her last day today, but I've managed to convince to come on and contribute as well. So thank you, Debbie. As there are 6 of us and we only have less than an hour, we'll each spend around 5 or 8 minutes or so talking about how our work intersects with the issue of children's data privacy and the challenges that we think this presents going forward. We should then have some time for some Q&A. Please, anyone in the audience, if you have questions, put them in the chat and we will address those at the end or toward the end of the session. Okay, so first I guess we need to think about why do children need special protections and what are the risks? So just briefly, basically children use all the same internet platforms, apps and services that we do and more. And these are owned and run by global and international organisations. They use these in their own time, they use them at school, now more so than ever because of COVID. We've tried to get everybody working remotely through digital technologies. And these collect personal information from children, and much of it is aggregated with other data. And when that happens, it can reveal very sensitive information. So we might think collection of one piece of information isn't that significant, but in the aggregation process, that then becomes a bit risky. So more often than not, it's regularly used for purposes that children and parents don't know about, and it can be harmful and discriminatory over the longer term. And there's a lot of research and work that's been done in policy in different places to that effect. And I guess responding to these concerns, there's been significant advances made to strengthen children's data protection rights. And of course, the first one that comes to mind is the European Union's General Data Protection Regulation, which was brought out in 2018. So it's only 4 years ago. This is all pretty recent. And this acknowledged children as requiring special protection. And so I think that was a good, a significant point, that acknowledgement. And this is because it's argued that they may be less aware of the risks and the consequences of the processing of their data. I would also argue that parents and adults aren't that aware of the risks of the processing of their data. Anyway, so it was a good step forward. The GDPR basically obligates all its member states, if you like, to legislate around issues such as ensuring that data processing does not exceed the uses that children or parents have consented to, which is an interesting thing, that public and private actors limit data collection, and that the length of time that children's data is held is minimal. So in doing so, it introduces an age threshold and the idea of consent. So it requires parents to consent for the collection of children's data That's the younger children. And for teenagers as young as 13 to be able to manage that process themselves and understand what they're consenting to. It also introduced rights to retract, correct, delete their personal information, and also prohibited the use of automated decision-making with regard to children's information when it's done without any human oversight, which introduces all those interesting ideas or tools like algorithms and etc. Anyway, okay, so following that, the UK, which now isn't part of the European Union, but it followed in that sort of footstep and introduced the Age-Appropriate Design Code, and is managed by the Information Commissioner's Office. This sort of took the approach, I guess, to help businesses and institutions kind of interpret the GDPR and what they needed to comply with. But it also invests in supporting that self-management model. And so it does that through education and awareness campaigns and trying to raise these subjects within schools as well. So essentially this age-appropriate design code requires that all information society services, commercial, institutional, etc., civic, provide default settings that ensure children can have a maximum sort of access to internet and digital society while also minimising data collection from them. And also to have things like profiling and geolocation tracking default off, right? So that actually is a huge mindset change from just the carte blanche, let's collect everybody's data, to considering that actually we may have to have these default settings on off, and people have the option of then opting into whether they want to be tracked for advertising purposes, etc. The third thing I'd like to mention is the United Nations. We have compliance, I guess, or we've carried through aspects of the Convention of the Rights of the Child, but in 21, they issued a General Comment 25, and it was a really interesting document because it laid out a manifesto for children's digital rights. It really, again, reinforces what's happened in Europe and what's happened with the UK, and these sorts of things are also emanating out over 126 other countries that are sort of taking up the mantle. So this General Comment 25 basically urges member countries to legally prohibit profiling or targeting of children of any age. And of course, with the UN, they have an age threshold of 18 in the back of their minds, and that is for commercial purpose. So also to respect the child's right to privacy and automated processing of children's data, that it cannot be conducted routinely or indiscriminately or without a child or parent's knowledge. Okay, so overarching trends, I guess, internationally are things like data minimization, default settings on off when it comes to the collection of data from users, internet users, and prohibiting profiling and geolocation, and introducing the idea of consent as a requirement for the collection of children's personal information. All right, so that's the kind of background. That's my reading list. And then I was very curious because I thought, well, how do families manage this? I know from my own experience, it's pretty difficult. And the more technology we get and the more services there are, it's even, it's a blinding kind of challenge to read through every privacy statement. So I was very curious about how parents and children think about and understand privacy, first of all, in that digital environment, but also how they manage it, whether they care at all about commercial companies taking their data or institutions, whether they know much about it. So in a very short summary, parents and children are acutely aware of reputational privacy, and I think they do a really good job of managing it. Teenagers and even kids as young as 10 seem to know all about privacy settings and social media, and I think they've been told a lot from a lot of sources, whether it's at home or at school, about the risks of sending material that might be then shared on in the public environment. They're also really aware of keeping certain information secure, like where they live, the old stranger danger discourse around that. But also there is a kind of a sense of, or concept of privacy that we've had over the centuries. It's built that there is this kind of division between home and community and home and government. And so there's that kind of protection of the home space, which is kind of interesting. But so that was great. But basically they didn't believe that governments or institutions collected more than they knowingly gave governments and institutions. So an example of that might be schools, you know. So hang on a second. Yeah. So within schools, children, lost the page. Yeah. So I guess in the old days, pre-digital, that expectation was okay. You gave the school your address, your parents' names, your phone number, whether there were any special education needs might be discussed, or disciplinary record, or, you know, grades might be recorded. And I think parents and kids seem to think that that's still pretty much where it was at. So they weren't particularly aware of the amount of data that might be collected through the schooling system, for instance, or by all the kind of private actors that are now sort of involved in that education system. So things like educational software raise a flag for me. I could talk a lot more about what they thought and didn't think, but I'll leave that to questions later if people are interested. But I think what it all amounts to is that we're kind of living in a period of constant technological innovation, which makes it very hard for regulation and legislation to keep up. But we do, you know, most of it's pretty good. All these innovations have wonderful benefits. And they're certainly bringing, you know, things like big data analytics are bringing great benefits to people in governance. But as we adopt these new technologies, I'd argue that we need to think a bit more about how these affect the privacy of stakeholders, and especially young people and children. So I've sort of set the scene with what's happening, the sort of trends overseas, and now we're going to talk, you know, how we do it in New Zealand. What are the concerns? What are the achievements that we've made in terms of handling personal data, but specifically children's data? And if panel speakers can speak to sort of commercial and institutional uses of data here, that'd be really terrific. So I'm going to hand over to Mickey. Where are you? There you are.
Thank you. Kia ora koutou. Thank you, Caroline, both for inviting me to be part of the panel, as well as thank you for setting the scene. I'm going to focus and talk about a resource that is available to anyone who's collecting personal information, and how to think about it in ethical terms. And as this panel is about children, specifically thinking about how you can apply it to collecting children's information. But first, I'd like to introduce that I'm a privacy consultant to the Government Chief Privacy Officer. That's GCPO for short, because that's quite a long name. What GCPO does is leads an all-of-government approach to privacy to raise public sector privacy maturity and capabilities. So we're only focused on public sector. There are 63 agencies that fall within our mandate. What we do is we provide leadership about privacy across government. We work to build capability by supporting agencies to lift their capability to meet their privacy responsibilities. We provide assurance on public sector privacy performance by having agencies conduct an annual self-assessment using a privacy maturity assessment framework. And also we engage with the Office of the Privacy Commissioner and New Zealanders about privacy. Myself, since joining GCPO in 2018, I've focused on supporting privacy officers in government agencies to build the privacy maturity and capability by publishing a suite of guidance on digital.gov.nz. Digital is an open platform, so while this is targeted towards public sector agencies, anyone can access it. So just putting that out there. One of the main pieces of work that I've done is getting the data protection and use policy, DPUP, onto digital.gov. It was a policy that was developed by the Social Wellbeing Agency and has now been transferred to be entrusted to GCPO. So I'm going to focus on talking about a little bit about DPUP because it's an easy to use and easy to access resource that can help agencies and people collecting the information think about how do you ensure children's data privacy. So what is DPUP, Data Protection and Use Policy? It describes what doing the right thing looks like when you're collecting or use people's personal information. It puts people first. It's about being respectful, trusted, and transparent in your use and management of people's personal information. DPUP is something that's, as I mentioned, is available to all New Zealanders, but particularly agencies and people who provide their, people who use their services. I will add the website address at the end in the chat because I can't quite manage doing that and talking at the same time, but I'm happy to do that. So it's good for government agencies, NGOs, and providers of other services, which could include schools, could certainly access this. When DPUP was set up, it is a cabinet approved policy, and they set up 5 foundational agencies who will begin to be the first people to start using it, though it's open to anyone to use. And that's the Ministry of Education, who you will hear Selena talk about what they've been doing with DPUP later in this talk. Ministry of Health, Ministry of Social Development, Aranga Tamariki, and Social Wellbeing Agency. So what is DPUP? DPUP is made of 5 principles and 4 guidelines. It's not rule-based. It doesn't tell you what you have to do. So it's about, it helps agencies be clear about the importance of purpose. Everything starts with understanding why you're collecting the personal information, how you're going to use it, who you're going to share it with, and being able to help people then understand what is happening with their information and what choices they may have about whether or not they are required to provide that information, as well as making sure that when you're explaining it appropriately to either their age or context or language. And then also to make sure that you make it easy for people to know and request correction of their personal information. And finally, helping those who also access that information and agencies to work together for better insights and outcomes. So given that we have limited time, and I want to make sure there's time for everyone else to talk, is I'm going to focus on one guideline, the transparency and choice guideline, that I think is really appropriate to this conversation, because this guideline focuses on helping people to understand what information they're being asked to provide and why. It emphasizes that it's important to match the approach to the context. So that's, for example, in this case would be, how do you help parents and children understand what's being collected, why, who will see it, how can they make sure that if the information is inaccurate, how can they correct it? And so to do this, DPUP provides a tool that summarizes good practice and legal obligations when approaching such consent. The tool explains the core purposes of the consent process. It helps you to how to explain what information you need and why. And connected to that is how to help people understand their rights and how to check to make sure people understand. And that sometimes is a step that I think is forgotten, is that you go, okay, yep, I explained this and it's done and dusted, but you don't necessarily check back with the people to make sure that they have understood what you have told them. And then finally, to offer them opportunities to ask more questions in the future, because especially parents and children who may not know what questions to ask, but they'll go away and think about it, and then they'll want to come back, and how do they access to be able to ask the appropriate questions. I will put into the chat the more specific web link for the toolkit. Okay, so that's kind of my flurry of journey through DPUP and transparency and choice, and happy to take questions after everyone else has had a chance to speak. So there you go.
Oh, thank you. So Selena, do you want to go next?
I do indeed, thank you. So kia ora everybody, I'm Selena Smeaton. I'm very privileged to be the Manager of Information Management at the Ministry of Education. I work in a broader group called Evidence, Data and Knowledge. So we provide the leadership, direction and expertise on education, data and information, and do all the good things with children's data, doing evaluation of how well education interventions are working, creating insights, doing some amazing analytics, informing policy development, and also in particular, informing funding decisions as well. So I am, as part of that group, I am in a group called Data and Information Stewardship. So everything we're talking about today is near and dear to our hearts. We develop policies and practices and procedures and build the technology and the data platforms that children's data in the education context rests on. And my team in particular champions the safe and appropriate use of that data. So some of the pieces of work that Mickey was just talking about, the DPUP, for example, has been a real key tool and instrument for us over the last couple of years, along with other frameworks such as transparency and use of algorithms, some of the work going on across government and Maori data sovereignty, and other pieces where we're beginning to think about, well, how do we keep the right controls around personal information, but while still making sure that it does share value and can inform our system. So essentially, my team is mostly around providing privacy by design and privacy engineering advice, keeping in mind all of those things to all of the large programs of work that the ministry is doing. We provide advice, and we have to tackle with real life issues where we're trying to do things like implement digital identity. So, anybody out there who's got a teenager will know that they frantically try to log on to NZQA's website to get NCE results, right through to tertiary students who are looking to prove who they are every time they may sign up to another course. So we're in a world where we're trying to build capability going forward, where there's still very varied practice around things like using birth certificates for identification and taking photocopies versus using some of the broader pieces of kit like RealMe. A large part of our focus is the continuous improvement in the way that the ministry collects the administrative data that we use for policy and funding decisions. So in essence, we collect, the ministry collects attendance data, who's going to school, how often, and how, and who's not going to school and where. Attainment, so how well are Ākonga achieving at school, what's working and what isn't. Some very sensitive data, what we call pastoral information on the numbers of stand downs and suspensions and what are the trends across the country. So working with those types of data sets where we collect individual level information under the Education and Training Act, we absolutely have to build privacy by design over it. We do have to collect it at an individual level, but that is all very carefully managed in our data warehousing so that the information is only ever used and aggregated in confidential ways. So my team has a big role in how the data warehousing environments work, how the systems work, what we tell parents and children about what happens to information, and working with schools and principals and all of their folk on what needs to be collected and when. The ministry also has a big stake in other aspects around children's privacy, not just what we collect, but in the broader environment around what is used. So we work very closely with things like NetSafe New Zealand that are looking more at things like bullying online and how to keep children safe online. So there's quite a clear crossover there with some of the privacy controls. We also work with other autonomous companies such as Network for Learning that provide the internet service for all of the schools. And again, they're very interested in maintaining security and privacy over the network. So we have a mutual relationship of providing guidance and support and moving forward together there. Mickey talked about the DPUP. That is something that we are definitely have found incredibly useful to apply to all of our existing data processes. So I think the comment you made was earlier, Carolyn, was around the old days of what you gave schools. So you fill out a form with your parents and your age and all of those things. And honestly, I can remember that. It is very, very different now, and a lot more data is collected by schools. The majority of that does not come back to the ministry, but what we have done with the DPUP is we have worked with the sector to help them to understand the DPUP, to help them to understand whether it was appropriate and fit for purpose in the education context. And many schools and regions have also picked it up as well. Now, just to be very clear, for those of you here who aren't aware, education is a very devolved sector. So the ministry has roles around policy and funding, but we don't run schools. Schools are autonomous, they're run by boards, so they get to make their own decisions. They have a lot of their own legal frameworks and obligations. We do provide guidance, and we do provide support on where things at a national level like DPUP are available as tools. We also work very closely with other groups like NZ Star, and Sid will be talking a little later on about that. In terms of some of the realities of protecting children's privacy at a ministry regional level, education data is incredibly valued to a huge number of people, and all children are in education or should be in education. So we hold some really good and high quality data around children, but we have to be so careful around how it gets used and how it gets shared. We provide a lot of, in their regions, we work a lot with other agencies on that matter. So we might be working and doing some information sharing with Oranga Tamariki, with health and disability groups, with youth justice. We've done lots of work in the past and we'll continue to do so with police on their various community focused projects. So it's quite often you'll find that out in the regions, these kind of information sharing happen in person. It's actually like family group conferences or cross-agency meetings talking about communities and families that might be vulnerable and at risk. So we provide a lot of support around making sure that is done with the child's privacy at the centre of it. I think some of the challenges we have at a real practical level around the various services that different agencies provide can actually be on finding kids. So, and I know that my colleagues from MSD will have some of the same issues as well. Some of the most vulnerable children in most need of government services can often be the hardest to find. So, good example for us is we provide support to groups like the Dental Association of New Zealand, who are trying to find children to ensure that they get their free dental care. But we can't just provide addresses. We can't just give information out. So there's lots of different frameworks and ways that we have to very carefully work through to make sure that we help people to find children or to advocate for free dental services in ways that don't intrude. That, you know, nobody wants the government knocking on their door. So that's what we are avoiding. There's been a lot of interest recently about third-party learning tools. As I said earlier, schools do get to make their own decisions, but we do often get them coming back through to us, asking questions around what they might be using. I think in particular occasion we get parents coming to the ministry to understand why their children may need to sign up with a provider. There are a lot of parents that don't want their children to have Gmail addresses or to sign up to Microsoft suites. And if a school has made a decision to offer some part of the curriculum through that, then parents often want to know about their rights. My team provides ad hoc advice and guidance, but it is only guidance. We don't make decisions on behalf of schools. So work such as what Caroline's doing about increasing awareness and empowering parents, whānau and community to be more empowered about about protecting their Konga's rights in the digital world is really important, and I'm continue to work with people like Carol and other across the sector. Just a few other things that we have found really interesting recently. Over the last couple of years, we've been doing a lot of work about managing gender change in national systems. So some of you listening will be familiar with the fact that there's been a number of changes from DIA around gender markers. We've experienced for quite some time now of how do we manage this, a very complicated data ecosystem where you have national ministry systems and you have a variety of school systems, and you want to protect a child's over on a sensitive topic around that as well. And another challenge that I certainly don't have an answer to is when we have parents with custodial issues wanting access to their children's information, and the ministry does not have any right to access family court information or anything like that. So working through what do you do in those type of custodial arrangements is something that is definitely on the agenda for a closer look over time. Last thing I wanted to mention was that the ministry does collect, does a large amount of research and evaluation on education interventions. So everything from the Schools and Lunch program that people may have seen in the news over the weekend that's been nominated for award, through to all sorts of other surveys and evaluations where there's been a piece of education policy, it's been implemented, or there's been a proof of concept, and we want to know, has it made a real difference to kids? So we've developed an ethics committee to make sure that we have appropriate research and evaluation ethics over everything. That's an incredibly important part of upholding children's privacy, because we are making sure that surveys, questionnaires and tools are appropriate, that children and their parents and their guardians know exactly what they're getting into, what their rights are, and what they're consenting for. So we do a lot of work around that over the last year as well. So I'm going to finish now because we have more speakers. Happy to take questions later, and also I'm pretty easy to find in the Ministry of Education if anybody wants to talk to me at any time one-on-one. Always good for a chat. Thank you.
All right, so Debbie, would you like to have a go now?
Sure.
Thank you.
Kia ora koutou. So my name's Debbie Burch. I've been with the Ministry of Social Development for the past couple of years, working in the information group, and primarily focused on the data protection and use policy, which both Mickey and Selena have touched on today, but also working within their privacy, human rights and ethics framework, which is focused basically on looking at or assessing the risk, identifying and assessing the risk of any use of personal information, any collection of personal information, any storage or disclosure of personal information. And that's sort of extended over the last couple of years with the introduction of DPUP, where we're not just looking at people's personal information as such, but we're also thinking about other information which is important to individuals, groups, whānau, iwi, etc. So that's been a really good inclusion into the Privacy, Human Rights and Ethics framework, commonly called the PHRAE. I wanted to focus on an initiative which we've had underway for a wee while here at MSD, not so much on what MSD does with children's data and information, but what we've been, I guess, grappling with over the past wee while, quite a wee while actually, in terms of how we help support and build capability in the sector, in the social sector, around the use of personal information, people's information. So that obviously includes children's information too. MSD itself is obviously the largest operator in the social services sector, and was a foundational member of both DPUP and the Algorithm Charter for Aotearoa New Zealand as well. So this is really quite important to us. And personally, having a little tween who wants to be on every app under the sun, it's something which which is definitely important to me personally as well. So really appreciate being asked to talk today. So the initiative I wanted to focus on was around how we engage third parties in New Zealand. So in terms of the social sector, that's predominantly non-government organisations, and sort of Selena touched on, third-party providers as well earlier. We know MSD engages with thousands of third parties, so that can include whilst NGOs, it can also include private entities, iwi, other Crown entities or agencies, etc. So it's quite broad reaching. So what's really important for us is to understand what the nature of that relationship is. And so what information is involved is really critical to identify what the responsibilities are for both MSD and the third parties. When MSD has, I guess, hold of people's information, within our own systems, that's quite clear cut. We know we've got a legal, moral obligation to make sure we use that, to make sure we act responsibly with that information. When we fund or engage a third party to do a piece of work for us or on our behalf, that's not quite so clear cut. So that's where it gets a little bit grey. And that's what one of the things we've been grappling is, what's our responsibility? We could potentially turn around and say, well, legally, it's all on you, but actually MSD wants to, take a more, as I said, responsible approach to that. And so, we've looked at that as having a moral obligation to ensure that people's information is protected, even if it's not us holding it. We know people's information is really important to them. I think that came through quite substantially within the DPUP consultation. And we know that they care what happens to it. And so when we're engaging these third parties, irrespective of the size of the organisation, they all have obligations under the Privacy Act. And so when we engage those third parties or the NGOs, more often than not, involved some type of personal or sensitive information. And so it's really important for us to get this right. We know NGOs want to do the right thing, but they don't always have that capability or capacity even. And so what we've recently introduced at MSD is a third-party framework. It's actually got a longer name, but a bit like PMAF and DPUP. It's very much easy to talk about it in short. And that was what's been introduced as a risk-based framework, so that we can be clear about what our responsibilities are versus the third parties, and what assurances that we'll need them to provide when they're being funded to do a thing. We're lucky to have social service accreditation, or now called Te Kahui Kahu, who goes out to, or who operates on behalf of 6 government agencies to kind of do some basic checks and make sure that their processes and systems, etc., are working well and are in place. We know that some higher risk scenarios may require independent privacy impact assessments or security risk assessments. And again, we're wanting to go, well, how can we help those NGOs actually meet their own obligations? So ultimately, we're trying to look at how we can build the capability in the sector and make sure that those people, including the children's information, is safe, it's being used responsibly, and there's that transparency there as well. So that's really key. The data protection use policy in particular has been really instrumental in terms of thinking about not just what we need to do to meet the Privacy Act, to be compliant with the Privacy Act, but actually what's the stuff we should be doing over and above that. So I like to sort of talk about DPUP as the Privacy Act on steroids. So that's been really, really key. There are, we've got lots of different sort of things happening at MSD. We know that, we need to do this right. We know that, that for New Zealanders to trust us and to have faith in the use of their personal information, that we've got to get this right. So, yeah, thank you. I'm happy to answer any questions at the end as well.
Thanks, Debbie. We'll just go to Sid. Sid's from the New Zealand Schools Trustees Association, so he deals with people in education all the time. We're really looking forward to hearing what you've got to say. Sid, over to you.
It's always a bit frightening when someone says something like that, Caroline, but thanks very much for the opportunity to, and kia ora tātou. Selena has described the landscape we're working pretty well. I mean, we advise 2,500 Crown entities down the country, and we're not a government agency either, although disturbingly some people act as if we are and take our advice as gospel, which is nice and flattering, but a bit frightening as well. I guess in relation to privacy in general, well, in relation to our advice to school boards in general, all 2,500, I guess we try and do two things. One is that we try and explain to school boards who don't know what the law is in New Zealand, what the law is that's relevant to them, and suggest quite tactfully, usually, that they should follow it. And so that includes, obviously, the Privacy Act. The Education and Training Act that came in 2020 then very and helpfully, specifically said that school boards were required to ensure that the school gives effect to relevant student rights. It then talked about the student rights in the Education and Training Act itself, the Bill of Rights Act and the Human Rights Act. And I guess I am in the habit of stretching it a little bit because the Bill of Rights Act and the Human Rights Act say that they're there to help implement our human rights commitments in general. And so I also bring in privacy as part of the obligation to respect relevant student rights and say that the student's right to privacy is a relevant student right that needs to be ensured by the school. I think it would be fair to say that many of our school boards tend to take a risk management approach to issues like privacy. And so they will tend, and they'll certainly come to our attention when they become aware of perhaps contravening some sort of legal requirement and are worried about managing that. And so we get queries about information requests. We give advice on redacting personal information as part of responding to official information requests. We give generic advice about the Privacy Act. I don't know how many people read it. We probably frighten the school boards that do read it into thinking that they're all going to suddenly be finding themselves in court and hauled over the coals for ignoring one or more privacy principles. But I would think in general we're fairly reactive, and I think that's probably true of many schools' approach to the privacy rights of the young people that attend the school as well. I'm often in the business of urging that schools take a more proactive approach to some of these things, that one of the reasons to have regard to the privacy of students is not just to avoid potential legal risk on the part of the school if privacy is violated in some sort of way, but schools are in the business of helping develop informed, critical and responsible citizens. And to do that, the curriculum argues, and I'd argue that schools ought to model critical, responsible, informed citizenship. And that includes, for example, that when teachers helpfully suggest to all students in the class that they sign up to a particular app, that rather than just click on agree without thinking, which is what most citizens do, that they actually should read the agreement and model responsible approach to privacy and protecting one's own privacy in the classroom setting. And I would guess that many teachers don't do that because it's seen as an ancillary aim rather than going to the heart of what schools are there to do. And I think that's probably one of the vulnerabilities in terms of protecting children's privacy as they sign up to all sorts of third-party apps, often at the instigation and suggestion of their teacher. So I think slowly what we are probably trying to do is to convince our school boards that they're in the human rights business. And obviously they're there to realise the right to education. Otherwise, why do we have a universal education system? But instead of seeing these things as irritating restrictions on freedom of action, see it as going to the heart of what schools and teachers are there to do. And so, as I say, model appropriate approaches to privacy when they come up in the classroom situation, as modelling protection of one's right to privacy, including explaining why those rights are important and what happens when those rights are violated. But as I say, as an organisation, we're fairly reactive. We respond to the 50% of school boards that contact us on a fairly regular basis, which suggests that 50% don't, and we don't have any direct control over what they may do, of course, even though some people think to the contrary. So I'm interested in this, in exploring this space. To be honest, I don't know much about the risks to privacy entailed in children signing up to various online applications. We have talked to schools about the significance of the changes to the Privacy Act that were brought in the revision, including their responsibility to ensure that information held about students is responsibly held and securely held. And although we've mentioned it, I'm not sure we've given particularly useful advice yet about how schools are actually to do that. And I look forward to looking at DPUP. I didn't know about it, which just shows my ignorance about the matter. So I look forward to seeing if there's any help there. Anyway, I'll stop there at that point, I think, and join in any answers to any questions or conversation that we have.
Excellent. All right, Kate, you're on.
Thank you, Caroline. Kia ora tātou. Ko Kate Rickaby tōku ingoa. So I'm a Principal Policy Advisor at the Office of the Privacy Commissioner. I will try and keep my talk nice and short so we have some time for questions at the end. So firstly, I want to extend a huge thank you to Caroline for your work to bring this event together. We're really grateful to you, Caroline, for pulling together a discussion on this really important topic. Thank you also to all the rest of the panelists for your contributions. We're really excited about the discussion today because children's privacy is something that we're really interested in here at OPC. Alongside the really insightful comments from the other panelists, I'm also really interested in hearing from audience members if we have time. So please do chime in and put your thoughts into the chat and let us know what you think. So we're very aware that there are some unique challenges and opportunities when it comes to the privacy of our tamariki and rangatahi. So we want to learn about things like the role of parents in protecting the privacy of their children and young people, the role of schools and other institutions, and of course the increasing presence that technology and social media have in a child's life and how that's impacting privacy. So as you will all know, the Privacy Act 2020 applies to the handling of children's personal information. So I do want to point out a legal provision that's particularly relevant in this area and might be of interest. So some of you might already be aware that in 2020, the Privacy Bill passed, making a number of amendments to our privacy laws here in New Zealand. So there's one key change that's quite relevant to our conversation today. So Information Privacy Principle 4, or IPP4, has been clarified to require agencies to ensure that the way they collect information from children and young people is fair. So this acknowledges that it might not be fair to collect information from children in the same way as you would from an adult. So agencies may need to take special care with the information to address any power imbalance, obtain genuine consent or the authorisation of whānau. So again, I'll keep this nice and short. Hopefully there are questions. I want to thank all of the panel members for the fantastic insights they've provided today. It's been really useful, really insightful for me. I am also really interested in continuing this conversation after the panel session. So if you do want to get in touch to share your thoughts, you can email us at policy@privacy.org.nz, and I will pop that in the chat as well. Thank you very much. Over to you, Caroline.
All right. Perhaps if everybody unmutes, we can perhaps have some discussion between us. And I don't know that there are that many questions there yet. But one of the things I'd like to say is really interesting to finally get everyone in a room to start the conversation. It's interesting, I think one of the things I've talked to most of you about is this idea of parental consent and consent from children, which there's a lot of work going on in the Northern Hemisphere around that issue. And here, like when people from government talk about how they collect and handle data, my understanding is that we are making an effort to ensure that when people are involved in that process, they understand why the data is being collected. But it's not necessarily a situation where they can opt out of having that data collected. Is that right?
Well, from the education perspective, there are certain types of information that we do collect. So under the Education and Training Act 2020, we have the powers to collect that. So I mentioned earlier, they are things around attendance and enrolment, attainment or achievement, and some other bits and pieces. Now, they are collected by the ministry largely through school management systems. When children enrol at a school, parents or caregivers or guardians do have a number of consent forms in front of them which indicate which data will be going to the ministry and for what purpose. There has been some work at a school level on improving those consents in the last couple of years, and there's also been some guidance from the ministry around that. I think it's important to note that there's absolutely the privacy obligations around consent and what have you, but ultimately part of the reason we collect data is that everybody in New Zealand you have to have an education. I'm sorry, I forget the exact piece of the Education and Training Act, but you must send your children to school. So there are some key things that we must know. Is your child actually enrolled at a school, and are they actually continuing to attend that school? So it really comes down to that in terms of the legal authority for it. But then the privacy by design comes in. Are we collecting just enough to do that, and is it being collected in the right ways?
Thank you, Selena. I've just seen a couple of interesting questions. Marcin Bitkier has asked, thank you for your presentations. I'd be grateful for clarifying the relationship between the MSD's framework for third parties and the New Zealand schools. Have schools been advised to use that framework? Those frameworks, do they use it? Do third parties that supply learning tools for schools use that framework? And I'm wondering whether that also, when she says third parties, does that include third-party software or management systems, administrative systems, Google, Microsoft, and all those apps that are regularly and irregularly used within school systems? So yeah, MSD, where are you? Debbie. Do you want to have a go?
I was trying to get rid of the question in front of me. Yeah, so actually the third-party framework's actually just recently been put in place, so this year. So prior to that, and actually probably it's probably not so much schools, which is probably more in Selena's kind of realm to answer, but some of the third parties or third-party contract types, which MSD engages a lot in relation to children, is actually with our OSCA providers. So your before and after school care, holiday programs type of providers. So and actually, sorry, what are they called? I should know, daycares and that type of thing. So for us, it's making sure that what we're trying to do is to actually help build the capability out there, because we know that some of those providers, you might have Barnardos, who's quite a big provider, and you could assume that actually they've likely got a fairly good maturity in this space, whereas you might have a little solo mum who's actually staying at home and looking after kids under the PAWS program, for example, who has probably never ever thought about what this means for her in terms of what information she might need to know and collect and share and whatever in relation to their children. So we're trying to take a balanced approach. We don't want to it's really important not to cripple these smaller providers who are ultimately there to do the right thing for the kids, but to also, as I said, help them to meet their own obligations. And so I think with DPUP, like the transparency and choice guideline, as Mickey mentioned, is really, really key. What we probably haven't done very well in the past, and I say I probably shouldn't talk on behalf of any other government department, but I might just do that, is that we've always been a little bit more black and white. So we need your name, date of birth, address, this, that, the next thing, when actually we need to start thinking, yeah, it would be helpful to have this information, but actually is this something that we could provide them as a choice? So do we need to collect that information from everybody, or is actually a sample okay, or could we collect it in another way? And that might be working with the Ministry of Education or whoever. So yeah, I don't know if that kind of answers the question, but it's not something we are going to do retrospectively, retroactively. So it's a framework that we now have in place that we're using going forward to make sure we've got the right sized assurance in place, and helping to be assurance framework in place, and also helping to build the capability where we can within the sector.
That's good, and carrying on from that, I think someone else has asked, what happens if you give consent and then decide against giving the consent? What is in place to ensure this is amended? Can people delete data? Can they withdraw their consent, and can that be done? So
absolutely. From an education perspective, I mentioned that we have an ethics committee, and this is something we're very strong on. There is the data that you may be notified that it's going to be sent. So I talked about that, but then there's all the surveys and evaluations and other collections we might do. Every time that we provide support on that, it's making sure that people have the right pathway to withdraw their consent, as simple as an email to get in contact with a person to withdraw their consent, and then that means that their data will be removed from that type of work.
So we've got some other interesting questions here. What about the collection of children's biometric information? Is that covered under the New Zealand Privacy Act, Kate?
Thanks, Caroline. Yes, we actually recently issued a position paper on biometrics. So I'd really encourage that person to take a look on our website and have a look at that paper. It is covered though, yes. Yeah.
Excellent. Okay, well, I had some ideas around that when I was asked by an accounting company to go through a verification of my identity. With this, I think it has to do with the money laundering law, and it wasn't a comfortable process, and I backed out because I went right through this thing, and then suddenly they said, right, we want your facial recognition, and I went, what? I think a lot of people feel the same. I feel that's getting down to the wire. That's the real me. It's the closest, most treasured piece of identification, I think, certainly in the future of how we interact in our society. So yeah, I think that's a really important thing to be debated. There's a couple of other really neat questions here. do you have any thoughts about balancing children and young people's right to privacy against parents' need or desire to access or control their child's information? That's a really interesting thing. The UN guidelines are quite interesting. There's a lot of research around children's need for privacy and their development, and their need to explore their identities and develop their worldviews. And so having access to information and being able to use everything that adults use in terms of information and learning and connecting with people is important. I guess there's a lot of developmental science around at what age children can have access to certain things in a healthy way. But I also think it draws out another really interesting conflict in terms of all the rhetoric and narrative and discourse around ensuring children are safe online, ensuring that they're great digital citizens, that they don't cyberbully. You know, there is in that narrative a really heightened discourse of surveillance of children, which I don't think is particularly healthy. Personally, they've got to be the most surveilled portion of society, really. So, and I think with increasing digitalization, that's got worse. It certainly probably got worse through COVID. And connecting children everywhere to their schools and to a lot of people that they wouldn't ordinarily communicate through digital means. So yeah, so it brings up a conflict too in terms of parents wanting to ensure that their kids are protected. So the idea that a school signs a primary school kid up with a Gmail and comes home and says, Mum on Gmail, is actually something a lot of parents are quite taken aback about. You know, it suddenly opens up the world, the kid to the world, you know, gives them access. And true, I've heard some horror stories and with parents who have gone back to schools and said, hey, you're not even monitoring what the kids are using that you've said to use in a classroom, and here's some creepy people in there doing bad things, you know. So there is a lot of monitoring that needs to go on, but we do need to respect their right to information. And under the UN and the manifesto that's sort of emerging from that is really about balancing children's right for that independent, greater autonomy as they grow and access to information and education with that. Hope that answers that question. Okay. Any other questions? Can people see there? Have I missed any? Oh, yes, there are. Okay. How does the Office of the Privacy Commissioner view the tension between the need for the collection of children's data for security and safety versus privacy? Interesting question there, Kate.
Yeah, it definitely is a really delicate balance. I'll try and keep it quick because I just see that I've just seen that Jess has put a note in there noting that we're past 1 o'clock. But yeah, we're definitely very mindful that there's a really delicate balance to be struck there. So on one hand, using personal information to ensure a child is safe, healthy, flourishing, but only when that's necessary to achieve a justified aim. And of course, with all the appropriate parameters and safeguards wrapped around that. So yeah, it's a really delicate balance, and it'll be really context dependent on the particular situation.
There's just one last question I think we'll leave on. It's got under the GDPR, if an organisation is gathering data from children that relates to safeguarding, then parental consent is not required for sign up. I'm not sure what they mean by it. Do we have any similar guidance around this in New Zealand? I guess what we're asking is, is there parents required to consent here, or is it just a free-for-all that children just tick the cookie consent box? How does that work? I mean, it's a kind of a legal contract that people enter into when they tick, yes, I would like to use the service. So how does the Privacy Act sort of interact with that consent, a question of consent? Does it interact with a question of consent? in terms of commercial providers? Kate.
Sure, that's a great question. I actually wonder if that might be one that one of the other panel members want to pick up.
I'll jump in because I'm never too shy to jump in. But to me, this goes to the heart of what I was saying before about the role of schools and teachers if it's happening within a school setting. I mean, to me, it would be folly to imagine that the general public don't just click on agree whenever they're given a set of conditions. So to me, it's incumbent on a teacher in a classroom to actually explain what people are possibly agreeing to and actually have a discussion about that.
Yeah.
I think the school has an obligation to understand what the conditions are and explain them in terms that kids might understand before they click on that anyway, quite apart from the issues raised by the question.
I think it highlights, just as a parting note, the tension between schools and families. You know, are parents getting the opportunity to, are they informed about what data is collected by the private sort of software that is used within schools, for instance? Do they get the opportunity to opt out? Are the children aware? Or is it just something that independently each individual school decides not to address? Or are we still sort of only thinking about whether it's okay to take pictures of Johnny and put them in the newsletter? You know, is it still at that level? Are we actually thinking about data, like data that's collected, which, you know, extends to things like performativity, how well children are succeeding when they're doing a math program on the internet, you know, and what about behavioural information which is picked up and sometimes manually entered into these systems and becomes a record against that child? So lots of really interesting things that I think we can go forward and discuss in our next panel. I'll let you all know when that will be. Hey, thank you very much for attending, and thank you everyone for listening. I see we had a pretty good attendance, so there must be quite a lot of interest. So audience, feel free to contact any of us to ask any more questions and to collaborate on some of these issues going forward. Thank you, guys. It's been really great. Cheers.
Thank you very much. Bye, everyone.